we'll get you back into court in just a moment. But first, here now to discuss defense attorney, former head prosecutor Bob Bianchi. Bob, of course, thank you for joining us both this afternoon. Here's my question, because each little detail does start to add up. There's clearly a relationship between Monica Sementilli and Baker. My question for you, what would you think, especially as a former prosecutor, if you hear in January of 2017, when all this happened, there were 5,752 messages between Baker and Monica Sementilli. Does that mean they were definitely conspiring? That's a lot. I looked at my messages. Michael's never texted me that much.
I was going to say, I got 4,000 in my phone from you right now.
There is so much that I could say about that comment, Judge. I'm just going to let it lay.
Thank you, Bob. Moving along.
Yeah, well, listen, I mean, it's funny you bring this up because I want to always try to provide a little bit of a different flavor and a context because trial work is so depth and there's so much texture, to the whole thing. And a lot of it is dealing with human nature. And I always used to regale people that I'm not a very bright person, but I'm an astute observer of human nature. And what I mean by that is that sometimes we can jump to conclusions. And I've seen this happen in my work as a homicide prosecutor investigations many, many times. We jump to the who has the life insurance policy or who's in the lack of an or who has an acrimonious relationship or who may be cheating on somebody and how many texts. And when we start doing these divining rod kind of things, or even when people lie, a lot of people jump to or assert their right to remain silent. I'm giving you literal instances in which my detectives were ready to pull the trigger, no pun intended, on somebody and arrest them for a murder case that later it was determined somebody else committed. So when I'm listening to this kind of testimony, honestly, what I'm saying is I'm putting my prosecutor hat on and I'm like, I'm really uncomfortable so far. I haven't heard anything other than they've established a great relationship between Baker and Austin, two individuals who we clearly know were involved in the murder. But am I being satisfied? Is it satiating my desire to understand whether or not it connects this defendant to that plot, especially when one of the co-defendants was allowed to plead guilty, not inculpate or give a statement against this defendant, and is actually going to be coming in as a defense witness, which is a very unusual thing that prosecutors allowed to happen. So when I'm listening to this, Judge, to answer your question, I'm uncomfortable. I don't care how many messages there are. I want to see the evidence that proves to me, before I even walk into the courtroom as a prosecutor, that not only beyond the reasonable doubt, I've tried a lot of hard cases that I thought maybe the jury may not agree with my evidence, but I was always convinced beyond all doubt that the defendant did it. I wasn't jumping to conclusions and guessing, and I'm just not satisfied right now.
You know, you talk about jumping to conclusions. That's the stock and trade of defense attorneys, right? We attack the cases because we say people jumped to conclusions. But I will say this, Bob, what we have is an email that initially I thought may have been, something that they jumped to conclusions about. An email sent to a name that wasn't directly connected to Robert Baker. But what we ended up finding out was connected to an account for his Gmail. So at the end of the day, that to me is an overt act. When in that email, it has information about how to get around or disable the security system.
Yeah, I mean, it's hard to say. Again, we're interpreting a lot of things here. And one of the best investigative people that I've ever dealt with on something just specifically like that, cover-ups, people who are lying about things, always caution to be careful because we're doing a lot of interpretation here. And I'm not disagreeing with you. There could be evidence, but that's why it's an uneven playing field as a prosecutor, and we have to prove a case beyond a reasonable doubt so that little shards of evidence don't lead to potentially a false conviction. So we'll have to wait and see. I mean, obviously this prosecutor, I listened to one of the statements that one of the, if I may, one of the prosecutors was saying, in another case where it's like, well, we wouldn't charge unless the person was guilty. And we obviously know that that's a bad way to look at things.
Yeah, I couldn't agree more.
That's interesting.
Before we head back to court, let's bring back in our guest, defense attorney, former head prosecutor Bob Bianchi, to discuss. Bob, there's a couple of places I could go, but I want to go back to this idea of jumping to conclusions. And I want to point to the 5,000 texts that we talked about. And I thought back to the opening statement by the defense. And you talk about jumping to conclusions. They basically said, look, when you're going to look at these texts, Most of them, and this is according to the defense, are from Robert Baker, to Monica. And they're trying to paint this picture of obsession because their claim, and when they put Robert on the stand, he's going to say, look, I did this on my own. I really wanted to be with her. She didn't tell me to do it. That's a perfect example where when you take those 5,000 texts, it could really be worked for the defense.
Yeah, and the defense doesn't have to be right either, Michael.
Right.
And it's almost like a weird psychology and psychopathy when you go into a courtroom. It's like the jurors kind of expect the defense is going to take some haymakers and throw some wild punches out there. But for prosecutors, it's different. You've got to have the evidence. You got to have the goods. You're the one asking the jury to do something that's going to lead. They know, even though they're not told, it's going to lead probably to a jail sentence. Certainly in a case like this. So yeah, but this point may be very logical. And I ask you guys rhetorically back. I mean, in all the cases I've ever handled in my career, whenever as a prosecutor, we believe that there was a conspiracy between one or more people involved in it, they were not allowed to plead guilty or receive the benefit of any kind of favorable treatment from the prosecution unless they gave a quote unquote truthful factual basis that implicated and inculpated the guilt of the co-defendant. In a case like this, Michael, right to your point, where the defense is going to be an obsessed individual who on his own acted out of love, not necessarily for an insurance policy or whatever, because he wanted to be with her, is now going to be coming in testifying favorably. And I'm wondering, I'm just curiosity, is the judge going to allow the jury to hear that the prosecution allowed him to plead guilty without inculpating the co-defendant, or the defendant rather, in this particular case? Because if so, I'm just curious, again, asking rhetorically, I think that's a big problem for the prosecution from a practical standpoint in the mind of at least one juror.
Yeah, I couldn't agree more. Giving that situation and prosecuting Robert Baker, he's in jail. He has no incentive not to come into court and tell whatever story he wants to tell.
And he got no contest, so he didn't have to admit his guilt. He has a long sentence, but it's just a little side note of what he got, which was pretty good, I think, at the end of the day. All right, stay tuned. Let's head back to court.